Now we'll start with Specific Relief Act 1963. Before we start, let us see the history of this act. This act was initially enacted in 1877 and this continued up to 1963. When the act was enacted in 1877, it was modeled on the New York Civil Code, embodied with equity codes. That's how the act was enacted in 1877. Then after 9th Law Commission recommendations, this act was this 1963 act came into force and we are continuing as on today with almost number of amendments. Recent amendments of 2018, everybody knew about that. The main object of this act is to provide relief to the parties suffered loss or injury due to breach of contract or legal obligation. If you look at this act of relief, SR Act, I'll say SR Act, the main thing is breach of contract and legal obligation. These are all if you look at every section, either breach of contract or legal obligation. And it's also, we'll use this act to enforce individual rights and obligations in relation to contracts. If we look at this provisions of the act, if we see these provisions, if we divide this act into some 2 or 3 parts, Section 5 to 8 of the act deals with possession and recovery of possession of the possession and recovery of possession. Then the main, whenever we deal with specifically, we'll say the contract. That is Section 9 to 24. That is specific performance of contracts. Then the other thing is declaratory reliefs, preventive and declaratory reliefs. That is main, that's we deal with under Section 34, 35. Declaratory reliefs, and preventive relief is from 36 to 39, 36, 38, and even up to 39 also it's preventive relief. That's how we have to separate this act. If we separate this act into these parts, it's easy to us to understand the provisions of the act and the gamut of the act also. If we see Section 5 of the act, which deals with recovery of specific immovable property, which is in every, wherever, especially in trial courts, a person come to us and say that somebody is in possession of the property and he is occupied my land and I need I have to file a suit for. You have to file a suit. Then we have to frame it. Is it under Section 5 or Section 6? Because if it is Section 5 or Section 6, this is very thin. Section 6 is concerned. Everybody knew. Even a owner disposes a tenant. Within 6 months, he can maintain a suit for recovery possession under Section 6. Within 6 months, you have to specifically plead and prove that I was dispossessed on a particular day and I am filing this suit within 6 months thereafter. The difference between 5 and 6, if you see 5 is concerned, you are asking for recovery of possession of the property, basing on title. If you see 5 and 34 have to go together, but 6 is concerned, it's an independent provision where you have to plead that I was dispossessed on a particular day and I'm maintaining this suit within 6 months from the date of dispossession. It's a summary in nature where court will not go into title aspect. Section 6 of the Act, that is something one should know the difference between 5 and 6. And against 6 there is no appeal lie. Section 6 is concerned, no appeal would lie against Section 6 because it's summary in nature. Court is not deciding any title of any party. It's only whether court will look into whether you are disposed or not. That's the only thing. And whether the disposition within 6 months or not. That is why Section 6.2 say no appeal would lie. 6.3 against the order under Section 6, no appeal shall lie from an order of decree passed in any suit issued under this section, nor shall any review or such an order or decree be allowed. That is the reason why only CRPs are being filed against the order under Section 6 of the Act. If it is under Section 5, court is going to decide as to your ownership. Then if the court satisfies that you are the owner of the property, court, if you have to see, because Section 5, we cannot say 5 and 34, that's what I'm saying, 5 and 34, where, for example, a third party comes and deny your title over the property. Then you are going to, and he is in possession of the property. Then the suit to be filed is suit for declaration, coupled with possession. There section 5 comes into play, where you have to lead evidence as to your one, you have to plead and prove your ownership. Once you prove your ownership, probably court, if the court believes that you are the owner of the property, then court also declares title as well as consequential lease possession. That's where the difference between, if it is 5, you have to again, you have to fall back, the limitation is also something different, and 64, 65. But if it is 6, it's only 6 months is the elimination, Act itself specifies that. There is a difference between 5 and 6, you see that. Then the main chapter we are dealing with is in a specific form in the Relief Act is 9 to 25, where enforcement of contract. This enforcement of contract is concerned, the recent amendment of 2018, everybody is thinking that there is a vast changes in the Act and the court now has no discretion. That will come to that. But according to me, still the court got discretion. That I will discuss with this. If you see section 10 of this amended Act, as per the amended Act of 2018, which comes into operation from 1st August, it seems. Specific performance in respect of contracts, it is subject to section 11 to 14 and 16. This is what the amendment carried out in 2018. The object of this amendment, if you see this object, initially, in fact, if you see this amended Act, there is a time frame also to dispose of the suits. This under this amendment, amended Act of this Relief Amendment 2018, the time was 20 months it seems. Yes, under this amended Act, it is the court shall dispose of within 12 months from the service of summons to the defendant, and this can be extended by 6 more months and an aggregate of regarding regions. The purpose of this amendment is to ensure, if you see these amendments also, section 14 coupled with section 20, the purpose is to see to it that the suits relating to infrastructural agreements, as stated in the schedule under section 41, energy contracts, are these things that they have to be disposed of at the earliest point of time, and the object is to see to it that if I see the object, 6-member committee constituted, they felt that because of this delay in disposal of these cases, the investors, nobody is coming forward to invest the amount in it. That's the main purpose. That's how this amendment was carried out in 2018. That's the reason why section 14 was substituted, and what used is substituted performance. That's what used in section 14 for the first time under this Act. As we know, the traditional practice is that agreement of sale, filing suit for specific performance, and the defense regarding section 12 deals with fault performance. What is the extent of the at what stage we can go for, and if it is if section 12 to say that if it is only small portion, still you can exercise your right, and all this section 12 and 13 is concerned the rights of purchase of lessee, and section 13 to 13b. If you see 13b, this is correlates to section 41 of the TP Act. Section 13b of the Relief Act, the reason why, especially from the lower court, my advice to number of my friends is that please go to senior and at least learn these, because if you see, you may be a good orator in the law school and you'll be first in the moot court, there is no doubt about that. But when it comes to, if you see section 13b here and section 41 of the TP Act, you will there's a complete, in fact, see, section 13b say, where the concurrence of other person is necessary for validating the title, and they are bound to concur at the request of the vendor or lessor. The purchaser or lessee may compel him to procure such concurrence with a conveyance by other person is necessary to validate the title. This is how the language in section 13b speaks. See section 41 of the Transfer of Property Act, where an ostensible owner, we enter, if we transfer the same for consideration, the transfer shall not be voidable on the ground that the transfer was not authorized to make it, provided the transfer after reasonable care, so and so. That's what. Then even after a person who does, the first principle is that nemo dat quat non habet. A person does not convey title better than what he is having. That's the first principle of law we are saying. But under section 41 of the TP Act, an ostensible owner claiming to be the owner of the property, if he alienate the property, by that time you don't have the title, but he acquires the title at a later point of time, still we can enforce saying that because you acquired the title, we can make good my title. The same thing section 13b say of the Relief Act. Section 13b also, concurrence of the other person, is similarity. So section 13b, when it comes to rights of purchaser lessee against the person who has no title, of imperfect title, you have to see these things so that you can also make use of it. Then, under this amendment, section 14 was completely substituted now. Section 14A, a party to a contract has obtained substituted performance of a contract in accordance with section 20. He can't maintain a suit for specific performance except for damages. That is also section 22 say he had to issue notes and section within 30 days. Then what is substituted performance? This is almost, we will say, a remedial measure. These substituted contracts, if what used in section 14, for example, there is a construction contract. We enter into agreement with a particular person to construct the building. For whatever the reason, the person failed to do the work and he could not perform as part of the contract. He is waiting for his completion of construction. You can proceed with the construction by a third party agency or by your own. You can complete the work. Now after completion of work, you can also you can ask for damages because his failure to perform is part of the contract. The sufferance you suffer, you can maintain a suit for damages. This construction contract, then service contracts, where you engage some labor, some personnel to monitor your service. Then he failed to extend that service. Then you do on your own, or you engage some third party, and the third party quotes more than what the other person quoted because you suffered. You will not in the normal course. You are supposed to file specific performance suit. You have to wait till the result. But by virtue of the substituted performance, which has been by virtue of 18 amendment, you can proceed with that. You can complete it. Still, your right for damages remains. But if you complete, section 23 say, once you complete, you can't maintain specific performance, but it will still have a right, so far you are concerned, for damages and for compensation. That is what the nicety of the present amendment. It is because, as I stated, the international community, they are not coming forward to invest the amount in India because the length of time these suits are being taken in India is concerned. This was amended and it's a recommendation by 6-member committee. And for this, as I stated, construction agreement, service contracts, land development, even manufacturing contracts, infrastructure, especially this is what infrastructure projects is something which we have to see that because of this infrastructure projects only this was in fact incorporated into this. Even engineering contracts, supply contracts, all this comes under that phrase. That is what section 14 speaks about, this supplement performance of this substituted performance. And one more section was incorporated, section 14A. If you look at section 14A, by virtue of this amendment, you will be knowing the importance of section 14. And section 14 capital A, court can get in expert opinion, court on its own. Because see, for example, this infrastructural contracts where a person completes enter into agreement and A enter into agreement B to perform certain project where there is some delay or something else, then B resigned it or B failed to perform, then A entered work to C, and after that A issue notice to B, then he files for damages. Then in such a case, court on its own can appoint a commission or an expert and to get its opinion, his or its opinion, and that can be made form part of the record in section 14(3), 14 capital A3. And you can also examine the expert also in this regard. It's not that the plaintiff or defendant can maintain a petition to appoint a commissioner. To refer an expert. The court on its own can do that. Because section 14 capital A say, if you see 14 capital A, 14 and 20, the amendment is only to see to it that the suits of this nature, because there is schedule under section 41, where 41 HA, the schedule speaks about transport, energy, water, sanitation, communication, and the social commercial infrastructure. That's how the schedule there. These are these contracts where the delay occurred. Nobody can be compensated tomorrow. If person resigns from the contract, then you have to file a suit for specific performance. It takes 10 years. Who is going to bear these expenses? That's the reason why this was incorporated. If you see even section 20B of this Amendment Act, 20B say, no injunction shall be granted. In this section 20B, 20 capital B, small b, 20 capital A. No injunction shall be granted by a court in a suit under this Act involving a contract relating to an infrastructure project specified in the schedule. While granting injunction would cause impediment or delay in the progress of completion of such infrastructure project. Section 14, Section 11, as I stated, Section 10, the specific performance is subject to Section 11 to 14 and 20. 14 speaks about substituted performance and 20 speaks about the performance and how you have to perform that, because under section 20, clause 1 say is entitled to, but that is subject to again, you have to issue notice within 30 days, then you have to institute. Now, without issuing notice, you can't maintain suit also in that regard, because you are completing your work. Unlike other suit where you have to wait for till, like if it is a regular suit for specific performance, where an agreement between two parties, you can't enforce it without, you can't proceed with further unless a decree is in your favor. But these contracts are concerned, you have to proceed with. Otherwise, tomorrow, the escalation of cost and all these things. That is the reason why this amendment of 2018 is mainly concentrated about this contract specified under schedule under 41 HA. After the decrease for specific performance, if the balance amount is to be deposited, court will grant certain time. Everybody knew about that. And the failure on the part of the plaintiff to deposit the amount, section 27 and 28, rescission. Notwithstanding the decree, if somebody fails to deposit the amount or adhere to the conditions of the decree, the defendant can maintain an application section 28 to resign, and the court will examine and pass order even in spite of the decree also. The reason why sometimes we'll say that like a partition, a decree of specific offense is preliminary decree but not final decree. Section 28 operates always. Then the main important is section 31. 31, after full bench judgment of Composite High Court, cancellation of document, where the matter was carried to Supreme Court, it's not directly, but in the other case, Gangalashmi case, it was overruled according to the same. Who has to cancel the document? Person who executes the document or a third party to the document. Shruti Singh's, Justice Ravindran judgment, 2010. It's a very, his lordship dealt with that a person who executes the document is the person who has to cancel the document if you have to maintain the suit for cancellation. Otherwise, a third party to the document has maintained suit for declaration but not for cancellation of the document per se. He is not executed. Maybe your right is affected by virtue of this document, particular document which was affected by A in favor of B. But you are not party to the document. You are a third party to the document. Hence, your right, you are supposed to maintain suit for declaration and consequential relief. But you can't maintain suit for cancellation per se. That's how this was Shruti Singh's case. Everybody, if nobody knows, we'll pass on the 2010 Justice Ravindran judgment. Then section 34, which is every second case in trial court or third case is declaratory suit. Everybody says declaratory suit only. What is declaration? It is legal character. If somebody say that a right to property which has been denied, then you maintain suit for declaration. A particular thing to declare a marriage, you are filing suit for declaration. Legal character and property both. Then can you maintain declaratory suit alone, or you have to ask for other ancillary relief? Please see section 35 on this. A suit for declaration per se is not maintainable, per se. For the reason, the ancillary relief you are supposed to ask for, if somebody denies your right to the property, and he is in possession of the property, you are filing suit for declaration and recovery portion of the property. If somebody is trying to invade, you are asking for declaration injunction, consequential injunction. If somebody is already encroached and made construction, you are asking for mandatory injunction. The purpose is to see to it that the decree should be implementable. A decree for declaration will not give, if it is you can't enforce it tomorrow, it's of no use. The reason why, if you see section 34, proviso, provided that no court shall make any such declaration where the plaintiff, being able to seek further relief than a mere declaration, omits to do so. And the other thing is that once the court declares a decree of declaration, the thing is this is right in rem, it's against world, whole of the world. But section 35 say it's only between the parties to the suit. When we are dealing with declaration injunction will say that it's personam and declaration is right in rem. Against whole of the world, maybe. But for example, A and B, A files suit against B for declaration and get a suit for declaration and decree is in his favor. C, who is a third party, he claims better title than A. And if he files a suit against A to declare his right, A cannot plead that no, I have already filed suit against B and there is a decree in my favor. Hence you can't maintain the suit. The legislation is very clear. If you see section 35, effect of declaration is specifically dealt with in the section 35 of the Act. A declaration made under this chapter is binding only on the parties to the suit, persons claiming through them, and where any of the parties are trustees and the persons for whom, if in existence at the date of the declaration, such parties would be the trustees. So in so many, it's very clear that though it's a decree in rem, but you cannot, if a third party is claiming better title than the decree holder, you can't say that no, it's rem, you can't maintain. Please keep it in mind. Then other thing, injunctions, preventive relief. One is possession, second one is enforcement of contract, then declaration, then preventive. When it comes to preventive, it deals with from 37, 36 say, 37 temporary injunction and temporary and perpetual injunction, 38 speaks about perpetual injunction, 39 say mandatory injunction. Very often we come across everybody using the word, I got temporary injunction or interim injunction. I'm sure there's a lot of difference between ad interim injunction, and perpetual injunction. Especially trial court advocates, sir, please keep the difference between ad interim injunction, temporary injunction and perpetual injunction. Ad interim injunction is concerned where the court grants injunction immediately when you file the application before it without issuing notice to the third party, the other person. Court grants injunction, ad interim. Immediately the court, if we satisfy the court, everybody knew that prima facie case, balance of convenience and irreparable loss. The court grants ad interim injunction immediately and then issue notice, direct the plaintiff to take out notice to the defendant or respondent in IA. Then after filing of counter, the court decides whether to continue or to vary the injunction. If the court makes the injunction absolute, that is temporary injunction. Or interim, that will add interim, then it continues till the completion of trial. After trial, if the court decrees, that is permanent injunction. Because we have been saying as an advocate or even after this side, I'm looking at, they said I got injunction. What is injunction you are getting? According to when somebody also, very latest one also, where fortunately and my sister dealt with one case, where ad interim was granted and police filed application for police aid. It was, sir, maybe sir, it will carry away, that's except see in injunction, to implement injunction, except judgment of Justice Manavendra Roy, where his lordship said that because ad interim injunction you can't maintain it. Otherwise, if you go to 82 AP Satyananda's case, they say if you don't see the difference between ad interim, temporary, then it says that only injunction is there, okay, implement it. Please maintain this distinction. Whenever you are using words also, please see this, because we have been coming across every time. Ad interim, and perpetual. And mandatory injunction is concerned whenever, and the one more thing, we are filing suit directly for mandatory injunction without asking for declaration. Somebody encroached upon your property and he constructs something. Then we are filing also suit for mandatory injunction without asking for declaration. Justice Fazil Ali, 1970 Madras. Very classic judgment. His lordship said, you have to ask for declaration of title, then only you can maintain mandatory injunction. A mandatory injunction suit per se is not maintained in 1970. Very, very classic judgment. I'll just pass on that also too. Because see, he may deny your title. Somebody, made construction, that means he is there, he made construction, it's not overnight construction sometimes. Of course, that's a different thing. Recently now overnight they are making, that's a different thing. But he is in possession of the property When you're asking for mandatory injunction without asking for declaration, there's also, you have to please see that whenever you're asking for mandatory injunction, according to me, you are asking for declaration also. That per se none. Then about 41, injunction when it cannot be granted. When diffuse, we say antecedent injunction. These things prevent to prevent execution. These things under section 41. When it comes to, this is what the specific relief act mainly say. One is the first part is possession. Second part, enforcement of contract. Then declaration. After declaration, preventive relief. Preventive relief is injunctions. As we said, the object is at every stage you see breach and legal character. These are at every stage you will find that. Breach is concerned if somebody encroaches. Then performance is even that is in 5 and 6 also you will find that. And the second part, declaration, this performance of contracts is concerned, there is a breach, somebody tried to breach the contract, then only you are trying to perform it. If perpetually is preventive is concerned, somebody is trying to encroach upon your, so is invading. So whenever, see, that is why the very object is to see to it that whenever you suffer injury, the injury should be legal injury and it's relating to contract or other. This is where the relief act, specific relief act holds the field. As I stated, section 13B and section 41 of TP Act, this relevancy. And when you come to substituted performance, when it comes to damages, again we are going to section 17th Contract Act. Contract, we have to determine the damage under section 73 of the Contract Act again. The relevancy is this act, Specific Relief Act, Transfer of Property Act and Contract Act, sometimes Sale of Goods Act. You have to read all these things. If you rely upon one single act, say that you want to proceed further, the other act definitely, the section, some defense may raise, because under section 9 you know, you can raise defenses which are legal under the Relief Act. Section 9 speaks about the defenses you are entitled to raise, the defense. And as we know, so far if civil suit is concerned, pleadings are very much important. Please, the Relief Act, we are supposed to stop with Relief Act, you have to deal with Relief Act, TP Act, Contract Act, then you have to frame it. And the relevance of Registration Act is concerned, if you see section 3 of the Transfer of Property Act, where it say registration is knowledge to every person. Of course, it's not in that language, but it is what we say. The language, the exact language employed, a person is said to have notice of an act when he actually knows that fact, or when, but for willful abstention from the inquiry or such which he ought to have made, or gross negligence, he would have known it. Where it relates to explanation 1, where any transaction relating to immovable property is required by law to be and has been effected by a registered instrument, any person acquiring such property or any part of or share or interest in such property shall be deemed to have notice of such instrument as from the date of registration. That's how somebody say that I am not aware of the registration and I am a bona fide purchaser. Immediately the defense is that section 3, the present service, and you are aware of this. Of course, everything is subject to exception. The exception you have to plead and prove. When we look at this Relief Act and Registration Act, the main thing is section 17 of the Registration Act, the document where the documents require registration, and section 17(1), and 17B say exemption also there for registration of certain documents. Because if you see a sale deed under section 54 of the Transfer of Property Act requires registration because if it is more than 100 rupees. Now even 17 of the Registration Act, 17(1)(g), you say that an agreement of sale requires registration, but exception is for 49 again, 49C. In a suit with specific purpose alone, You can press this for, but even for recovery of amount, in a suit for specific performance, you can't rely upon an unregistered document. It's only an exception to, in a specific performance suit and section 49C, in unregistered agreement also you can also present it for before the court. When it comes to Registration Act, executing the documents and presenting it after certain period. A document executed on this particular day, if you present it after 3 months or more than 4 months, I think you have to pay 10% of the registration charges as penalty. Document execution means we have to see the sign by the parties, then immediately you have to present it within that particular time. If you don't present it, then you have to pay 10%. Is filed before my court. When I pointed out this, the counsel immediately withdraw the writ petition and he want to execute one more because it's almost after 10 months he filed the writ petition saying that sub-registrar is not entertaining the document. And the other, I'll just give you that all. The other thing is that registrar cannot inquire into the title of the parties. That also you are aware of all this. You can't go into the dispute of the title except for whether the document presented is in proper manner or not, whether you paid the fee or not, whether section 32 capital A it is complied with or not. But he cannot go into the validity or the title aspect, except it's very thin line. He can't. If registrar start entertaining these civil disputes, we can only say that you can use this jurisdiction of civil court, and that is the Act says that it's no duty of the registrar to inquire into the title. And after full bench judgment, 22 Rule 26 1K1 came into existence, where unilateral cancellation, you cannot cancel the document unilaterally; it's only bilaterally. But still they are entertaining, and but it's in fact no registrar. It's no registrar because they are taking advantage of the word conveyance on sale. But when the Supreme Court in Gangalakshmi's case interpreted that it's conveyance on sale, and even other High Court judgments are there where gift deed has been said, you can't cancel unilaterally, still they are entertaining. In agreements of coupled with GPI, they are entertaining, they are cancelling unilaterally, but it is contrary to Rule 26 1K1. The overall scope of these two acts I just narrated, and any questions from, so that will interact is always better.
Sub-registrar cannot cancel the document
unilaterally.
Whether it is a coercion or fraud place, if any party unilaterally, but he has to go to the civil court.
Yes, absolutely, madam.
I had read in one general, Registrar General, Inspector General has a power or suo motu or any application by the parties,
yes,
can summons the...
How do you, madam? That's what, that requires evidence, madam. How do you say? See, you can't say that I was... See, you are pleading fraud, coercion or undue influence.
Undue influence.
Or you are pleading it. How do the registrar is expected to determine that without evidence and record?
That it is amended in the Registration Act and not...
No, it is only, madam, Senior Citizens Act only. Under Senior Citizens Act, where a document is executed to say that in lieu of to take care of the elderly people, if somebody execute a gift deed and the donee later failed to look after the welfare under that act.
Okay, sir.
That's different. But sub-registrar or registrar has no role to cancel the document unilaterally.
I had seen in one general, madam.
General is something different, madam. The provision is there.
Okay.
When section Rule 26K1, 1K1. Because, see, that's what we've been saying. Even, of course, in Telangana, when we practiced in Compulsory High Court, a reference was made to Division Bench, which is Nagarjuna Reddy Garu, where, in fact, I argued that matter. It's a gift deed. It was cancelled unilaterally. Then His Lordship pointed out the word uses conveyance on sale. Conveyance on sale, it doesn't include the gift deed.
Under AP Registration Act?
That's what, 26 1K1. Then recently, that reference was ordered by Division Bench of Telangana High Court. It's only 1 month back, just before vacation. They followed Thought Gangalakshmi and said, you can't cancel it unilaterally. A batch of writ petitions were allowed. What Gangalakshmi is a leading case. Yes, after Gangalakshmi, Sitaramurthy Garu said he applied it for gift deed, but still they are doing it. Still going on. So with this, I think, because it's already time is running now, please see the importance of these two acts where the first part is concerned, possession, second part is concerned, enforcement of our contractual obligations, third part is concerned, preventive relief. If you read, and the reading of these provisions also, please look that. Don't read it so casually. If you read it by giving pause, you will understand the concept of it. And because it's a issue now, it's been settled by 3 judge Supreme Court also, it's only prospective in nature, that we need not go into all these things. I think with this, I'll conclude my little effort on this subject, and I'll thank you all the participants, and I'll say good wish and also to the Bar Council of India. So thank you.